So essentially, what got us motivated to set up a legal practice was, in particular, the realization that the administrative law space in Australia generally is extremely underserviced. So what you have is a very intricate and extensive body of legislation.
Yeah, I was thinking, can you give me an example of what you mean?
So Australia is one of the most transparent countries in the world for governance and for government accountability, which means that it's extremely bureaucratic in a sense, because every aspect of the work of a government body is excessively regulated. How people work, who the stakeholders are of their work, who the beneficiaries of their work are.
You mean because of the FOI?
No, because of the Public Administration Act
and
the public sector communication regulations. Because of the Records Act, because of the Privacy and Data Protection Act, because of the Health Records Act, the Freedom of Information is a whole separate. Then there's the IBAC Act. New South Wales has more regulation than Victoria does, and these are just acts that deal with the general administrative sphere. Then each industry has its own set of regulations on top of that.
Yeah.
So it's one of the most regulated countries in the world for public administration. In fact,
for accountability.
So anything that a government body does is regulated. In fact, their objectives are regulated, which sets the equity considerations and so on. So very, very good space for litigation, because anything that they have to do is predefined. Now, at the same time, when we represented a large body of companies in very diverse industries, what we realized was the people that get employed in the different public sector bodies don't really get an induction that is in any way commensurate with the excessive regulation that they're subjected to. So they don't even know what laws they're answerable to. I mean, government lawyers will not, because the fact is that, and it took us months, several people at a time, with 18, 20 hours of work sometimes a day, to go through every bit of regulation, and so the acts and the regulations pursuant to the acts. That's what it takes to understand every bit of the administrative law provisions that apply. It is logistically inconceivable that any government body will spend that much time. And we're talking about lawyers, people that already...
They won't know everything.
They will not.
No.
The lawyers will not know.
No,
because
not even the people who work there.
Yes, the people that represent the people that work there will not.
Yes.
Because, are you familiar with the model litigant obligations?
Yes.
Pursuant to the Judiciary Act?
Yes.
That's a whole different set.
Yeah.
Then that's on top of the civil procedure thing and the different court rules and so on and so forth. So, in effect, what our long-term ambition is, or mid to long-term ambition is to effectively license content. So we're not a law firm in the conventional sense, in that we never started off with the goal to grow organically and to have a lot of direct clients. What we want to do is be a part of the industrialization of the litigation process. So we want to basically create processes that will optimize the way in which litigation is carried out. So we're not really a law firm in that conventional sense. What we want to be is a technology-driven process optimization entity that creates standard infrastructure that then the smaller entities can leverage, and B, we want to be consultants on larger projects on how to effectively manage litigation.
Are you talking about the knowledge base discovery?
Well, it's a combination of different things. So one, it's content.
Which is the knowledge base?
Yeah.
Yeah.
But that, I think, is more relevant to the smaller part of the market. So you wouldn't sell that to Ashurst or to Clayton Utz or Herbert Smith Freehills. So
they have their graduates to do that.
Not just that, but they will develop their own databases and resources. What we want to do, on the other hand, is effectively develop a set of project management tools. So effectively, what management consulting businesses do.
Legal project management?
That's right.
Yeah.
But not in a. We don't want to start a practice management software.
You're talking about legal project management, say litigation, say a tender, if it requires legal, say arbitration.
Yeah, we're very litigation specific. We have a very litigation specific.
You should look at arbitration, especially construction contracts, because they're looking at technology because I'm doing my master's. They're looking at technology not only on the discovery end, on the discovery end primarily, because in a construction contract you get millions of documents, right? But it's the algorithm. So there is, you can configure the software so that it will pick up certain things and not pick up certain, still there's a human or a group of humans who will look at the first kind of run, and then from there you then kind of pull back and see whether your algorithm is working correctly or not.
So we're trying to, depending on what you mean in a more elaborate sense by that, we're trying to do the same thing with, for instance, lawsuits against the government for misfeasance, corruption.
Yeah.
So what we want to do is create an algorithm for instance, strategy. So first, what would you do in terms of identifying what the specific cause of the issue is? Okay, so there's a number of steps. If you think of it as a flow, as a logic gate thing, do you understand what logic gates are? The flow sequences. Okay, so you check a specific thing, and then you check if, depending on what the response is, you check something else, and you check something else. Once you've gotten a committed response from the government body, then you go.
What's the next step? Is that what you're saying?
Yeah. So you.
I'm sorry, Sylvester, may I just respond?
Yeah,
because
sure.
they're dropping off my medication. Please put in mailbox. Sorry. Sorry about that.
No, that's okay.
I missed it. I had to drive my mother today. Saturday. What's my daughter's There's phone number. Sorry about that.
That's okay.
Okay.
So I'll give you an example, just so it's less abstract. A lot of the businesses we represent are disruptive businesses. So they use technology to essentially revamp the way in which a service is delivered. Normally these businesses are businesses that operate in industries with a very broad consumer base.
Mm-hmm.
So you're effectively focusing on services that are either essential or close to essential.
Like electricity.
Well, like accommodation.
Oh, yeah.
Like telecom.
Mm.
We didn't sell power.
No, but the customer, you're talking about companies that have a wide customer
That's
base.
right.
So in retail, electricity,
So
retail.
you have so the things that we've operated in historically. There's been the whole groceries and consumer and food related space, accommodation services.
Yeah.
Telecom, logistics again is quite central. So freight transfer.
Okay.
And in these, so one, you focus on industries with a broad consumer base.
Mm.
Two, you focus on a service which is fairly popular. So it captures the widest demographic or widest set of demographics.
Mm.
So what we're trying to do is not develop a better service, but a better service delivery method. So you identify a product or service that does well already, and you either sell the same thing or a very similar thing. So it's like McDonald's.
Mm.
You're not trying to create a better burger, but a better burger delivery system.
Mm.
They'll actually buy the fries from McCain's, and nothing that they do is, in terms of the food products themselves, is specifically made by them or for them.
Yeah, generally, yeah. So they're just rebranding.
White
branding. So if they're buying from McCann's for fries, you mean?
Yeah, so they use McCain for fries.
Oh, McCain, yeah.
Across the world. In different markets in Asia, they use McCain's for the patties, with the vegetarian ones. They use local suppliers for beef and milk and so on. But they're not simply white labeling the product and reselling it. What they're selling is process optimization.
Correct.
So that's exactly what we try to do. We try to optimize the service delivery system in a way that makes it more accessible, that makes it accessible round the clock, and that seeks to benefit from economies of scale and thereby reduce the overall cost. Now, generally what happens is we focus on markets where the change is taking place at the time. So we wouldn't get into an industry where everything is already sorted out, and then you're trying to reinvent the wheel. So what you're trying to do is something innovative. Either you're bringing a concept from a different industry, or you're using technology, or there's been a change in legislation, or litigate case law has been set, which clarifies something. So you're trying to get in early on. What will then happen is you're outpacing the legislation or the regulation for the industry. There'll be regulative things that will come in place.
So say modern slavery, for example, as a policy. I know you're talking litigation, but just for me to understand. modern slavery, there was a transition period of 2 years or something, and everyone scrambled to have a modern slavery statement, modern slavery policy. You want to kind of do a standardization of that whole process of people's economy.
I have very little understanding of the modern slavery.
No, there's nothing specific to it. It's more the requirement to create a statement.
Yeah.
And to have a policy, a statement published on your website and a policy.
To give you a relevant example from something that we've done.
Okay.
Let's say privacy. So we're currently working in a matter where we're suing a public sector body for a communication that the body entered against a client, which they were not lawfully entitled to. Okay. The communication itself is misrepresentative, but that's a whole different thing.
Yeah.
They
acted on something that they were not entitled to act on, is what you're saying?
No, they communicated content or facts that they were not entitled to communicate.
I see.
Because so they felt that because they communicated in that way because they were upset about something or the other. So they wanted to act out and do something prejudicial. Now, they did it in a very underhanded way, in that they didn't explicitly say something that was problematic, but it was a signaling game. So the other problem is that because they did not say anything against an individual, or the statement was not did not refer to any individual and a corporate entity, that makes the Privacy Act and other things inoperable. So in that case, the relevant legislative instrument with which we can attack them is the Public Administration Act, which sets out the public sector communication principles. So the reasons why a public sector body can enter into communication of any sort, and that includes communication with an external government entity, apart from IBAC. So the principles are there. Then there's objectives and their methods. So there is a list of, I think, 14 different situations in which a public sector body can engage in communication with anyone, including a public sector body apart from IBAC.
Or a private person?
No. So
just one sector to one public sector body to another public sector body?
Yeah, so outside of their own
outside of their own
group.
Yeah.
So those are when they have to warn people about an urgent crisis.
Yeah.
B, when there's a number of things, but there's 14 conditions.
Yeah, and they didn't fit in any of them.
No. Okay. Because so the 14 conditions are basically around A, an urgent need, B, an urgent need to warn, C, an urgent need to collect information that cannot be collected otherwise. So let's say if you're looking for a specific person, you put out a description of the person, so more people can give you information about, where they are, what they do. So there are 14 conditions like that, let's say. I forget whether there's 12 or 14, but none of those were relevant.
Okay.
So this is, it's therefore...
communication was out of line, in other words.
Unlawful.
Yeah.
Unlawful.
Unlawful.
So then that's misfeasance in public office, because it's a breach of the requirements of the law. The person that is undertaking it, obviously there's context.
So how do you then...
So we have an algorithm.
Yeah.
So the algorithm, the way it will work for these sort of breaches is that first you engage with the people that are directly involved. Okay, so you have let's say the minister. Then you have, depending on what the body is, but let's say the body. Sometimes there can be a few layers in between. Then you have the department. Then you have the person responsible for the thing. Now, if you were to design an algorithm for dealing with these cases, now the most important thing that you need to understand in all of this is that the advantage that the private entity has in the litigation against the government, data, there are excessive laws about retention of data. And the absence of data necessarily through common law principles creates a presumption against the government body.
Yes.
So data,
they lose a lot. Anyway,
that's the other thing. So this is a critical asset.
Yeah.
You have to control data.
Yes.
Second, you have to lock in evidence about intention. This is going to be critical to what sort of relief you're accessing. Third, you have to effectively discover communication.
Do you know they all use one system?
Yeah.
HPCN.
Yeah, but I mean, in terms of the subpoenas, the preliminary discovery processes and other things, intergovernment. So you need to do that. And then fourth, you have to have a very good understanding of all the laws, direct and indirect. And you have to effectively draw a perimeter within which they can do things out of discretion.
So, okay. So
let me just...
sorry.
It'll make more sense after I'm done. So, let's say in this example, body A. Let's take an example of coronavirus, right? So let's say body A published a statement. In South Australia, there was the pizza incident where someone was identified as infected with a particular strain of, actually they were identified as having COVID. And they didn't disclose that they were a worker at the pizza restaurant. And they implied that they were a consumer. Now, based on how quickly other people had been infected because of them, the scientists came to a conclusion that they must have a very contagious strain. Because if they weren't working there, if they were just a consumer, then they would have, on average, spent this much time and so on and so forth. Now, because of that, there was a lot of information about the business that became public knowledge. This was not information about the individual who was doing it.
Yeah.
Okay? So there's information about the business, and the business faced a lot of backlash. Of
course, yeah.
So there were a number of, public discriminatory action
hate crimes.
That's right. So now what you have to do in that case, for instance, is that you need to know that the moment you start speaking with them about, for instance, inquiring about the proper basis for doing what they did and so on, if you're a law firm and you're doing that, they'll immediately start blocking processes. They'll start engaging their defensive processes. They'll start getting careful. So you can't go from a high enough level. You can't go from the level at which you will engage in terms of litigation, because they will immediately get the lawyers in. The communication will be careful, and the data will be less accessible. You will not have any evidence around the intention or what background checks have been done, and this you need to know beforehand, because apart from the other considerations, for instance, in terms of the laws that may be applicable, besides the whole public sector communication laws, there will be health record laws, because effectively this implies something about the people that are. There will be at least things about the finance management. So the government is undertaking this much work. There's an expense associated with it, which may be against the legislation around the prioritization of competing things when you have limited financial resources. So you identify all the things, so you know what you have to check them on. Then you first engage with the lowest entity that was directly involved in the decision-making process. They're at this moment not reporting above them, because for them it's
they won't bring it up yet because
it looks bad.
It's true.
They think they will.
They're trying to hide it. That's what.
Yeah, that's right. That's right. And you need to. It's a game theory thing.
Yeah.
You create models based on game theory because they're based on cognitive biases.
Yeah.
Now they're trying to hide it from their superiors.
Correct.
And they also two things: A, because they've done something wrong. Almost always. Because the number of things you need to know to do the right thing is just extraordinary. Plus, they're lazy. Second thing.
Hello.
Hey.
Maria?
Yes.
Yes, I'm pleased to meet you.
Nice to meet you.
I was walking Jeanette through
call me Jenny.
Jenny. Okay.
Okay.
I was walking Jenny through an example of how we would algorithmically approach a typical misfeasance case. So, A, they suspect that they may have done something wrong. B, they don't want to be a headache for their department. So you start engaging with them, and you start with simple questions about why they did what they did.
They'll probably give you everything too. I have experience in those sort of issues.
So either they will, or they will start becoming defensive.
Yes.
Which means that they will deny the obligation to give things. That will start creating errors of law.
If they talk to their lawyers, they'll deny. But if they don't?
They normally don't at this stage.
No.
First. So they will either say that they're not responsible for giving reasons, in which case it's a huge administrative, it's an error of law, which will vitiate the thing in itself in some cases. Or they will give information in drips and drabs after you keep forcing them. So they'll give you a lot of contradictory information. Plus, they will, in fits, reveal information that will make the intention clear. So you'll get as much information out of them as possible to create a picture. It'll not be in one communication. And the idea normally is to keep pestering them, and they reveal one thing and another thing over time. So now that you've locked in intention, then you straight away go for a discovery process against the body above them. And what you want to discover is the communication. So at what point they said what to whom. Now they're not careful, so they would have said something. And that again gives you a lot of incriminating information. Normally you can do this through freedom of information. You don't need to do a preliminary discovery process for that necessarily. And then after that, you go for the preliminary discovery process about statistical data around how many entities they dealt with in terms of a similar issue, what the standard approach was. So you create a statistical pattern. The other thing is that the Discrimination Act, or the Discrimination Acts rather, so there's the Charter of Rights and Responsibilities here. There's the Australian Human Rights Commission Act. And then there's
not exactly a Bill of Rights, but
well, it enforces the International Covenant on Civil and Political Rights. So through all of those things, you can then, the onus is on the government where they've taken a step which is statistically odd to explain why that step was taken.
So you want to find a better way of doing...
No, what we want to do is create an algorithmic process which will set out like a set of moves in chess through which you can effectively discover. That's right.
Yes, okay.
Through which you can effectively discover things in specific kind of cases.
I see.
So
that's very interesting.
Yeah. So it's what we're trying to do is create game theory models for different litigation categories. And then...
That's actually pretty good.
Yeah.
It's like pestering them. Okay, next letter. This is what the next letter looks like.
And they're all template-based.
Yeah.
They're template-driven.
Correct.
So,
I mean, it has to be. Because if you want to do economies of scale, like you said, then your process has to be standardized. So.
And so then what you will do is, once the lawyers do get in, you'll have a number of traps for the lawyers. So, for instance, in one of them, there's Holland Wilcox... the statutory fraud.
It's chess.
the statutory fraud team was engaged.
Yeah.
Now, what with this regulator? So, with the Public Administration Act, there's the Victorian Public Service Commission, the body that is responsible for the enforcement of the principles and so on.
Yeah.
Now, they've come up with a set of code of conduct regulation, different for the employees and then different for the board of directors or the directors of an organization. So basically the policy... VPSC, yeah. So they effectively ensure that if a board of directors is aware of a problem, and if they're aware of a problem and they've not fixed it, then they're personally liable. If the problem... In a lot of cases, they will have show cause events for demonstrating why that was not because of a systemic issue.
Yeah.